The Committee on State and Local Government will come to order. It is Thursday, April 9th, 1:21. A quorum is present. We have, first up is a bill, Senate File 4511, Senator Marty's bill. I'm sorry. Senator Maye Quade, Senate File 4689.
Thank you, Mr. Chair. Thank you for accommodating my schedule. If we could, I would move the A3 amendment.
Senator Maye Quade moves the A3 amendment. All those in favor say aye.
Aye.
All opposed say no. The A3 amendment is adopted. Senator Maye Quade, to your bill.
Thank you, Mr. Chair. Members, thank you for agreeing to hear 4689, which as amended provides much needed safeguards on automated decision systems and electronic monitoring in the workplace. Automated decision systems, or ADSs, are AI tools that use machine learning, algorithms, or data analytics to assist or increasingly replace humans when making decisions about hiring, performance evaluation, promotion, layoffs, jobs assignments, discipline, or termination. While automated decision systems can be useful in theory, as with all AI, there's a tremendous risk of bias and threat of surveillance, which is why the common sense safeguards outlined in this bill are so important. Mr. Chair, I think it's important to note, too, that I don't believe that Minnesota companies want to surveil and obtain information they don't need on their employees, but tech companies build these tools in a way that says, here, you can do this really cool stuff and you can have really good efficiency, but what comes with it is the ability to gain information about employees that is both not necessary for work purposes, but also potentially illegal. So Senate File 4689 as amended would make clear that employers, if they're going to use electronic monitoring tools, they cannot use them to digitally surveil their employees to prevent them from following the law, to obtain private employee information like health status, disability status, religious or political beliefs, make predictions about the employee's beliefs or intentions or their personality or their emotional state. They can't use automated decision systems or electronic monitoring to take action against a worker for exercising their legal rights. They can't monitor employees in universally recognized private areas like bathrooms, locker rooms, pumping or nursing rooms, and religious areas. And they can't, employers can't monitor their employees outside of work or doing their work-related duties. Additionally, it would also prevent employers from drawing on facial, gait, or emotion recognition technologies, and also not allow employers to physically implant devices that collect or transmit worker data, including devices that are installed underneath the skin or incorporated into personal clothing or personal accessories. And so, Mr. Chair, you know, in the Labor Committee, we heard some testimony from folks about, you know, from the Chamber and from Business Partnership that the bill that I had originally was going to implicate all of these things, and I thought it better to just say, here's what you can't use electronic monitoring for, and here's what you can't use automated decision systems for which I think we can all agree these are pretty common sense things we want to leave out. And with that, Mr. Chair, I would turn it over to my testifiers.
All right, thank you, Senator Maye Quade, for your presentation. The first testifier listed on there is Nico Montag. Please make your way to the testifying table. And please state your name for the record, and you may begin.
Good afternoon, Chair Zhang and members of the committee. My name is Nico Montag, and I work at the Minnesota Department of Revenue. I also serve as Chief Steward for AFSCME Local 2829. I am here to voice AFSCME's support for Senate File 4689 and Senate File 4576. I am here to tell you about what AI implementation looks like at my job. I'd also like to thank Senator Maye Quade for authorizing this legislation. The Department of Revenue adopted the use of an AI software, Amazon Connect, in September of 2025. If a taxpayer calls MDOR today, they will complete that call not knowing that the conversation was summarized and transcribed by AI. Any worker data that is generated from the call is also captured by Amazon Connect, which includes the full audio and screen recording of the conversation. The transcripts and all other data of these calls is retained for at least 6 months. We are also subject to monitoring of all of our keystrokes, what's on our monitors, the quality, brevity, and accuracy of all our conversations with members of the public, and our timeliness on completing clerical work when a call ends. We even have to have changed our online status if we get up to use the bathroom. Needless to say, we are a very heavily monitored group of workers. MDOR's quality assurance team measures the quality of our work by randomly selecting calls that they can replay and score on a variety of criteria. Some of these metrics are very clear, like checking to see if we said our names. Others are a bit more nebulous, but at least we know that a human is the one evaluating us and that not every one of our interactions are going to be scrutinized. We might be constantly surveilled, but we're still watched by human eyes. But the AI tools that the state has implemented don't have to just sample a call here or there. It's capable of analyzing every call, and even our private moments, and compiling these results for our supervisors to review. In fact, Amazon's marketing materials for Connect state that performance reviews are a function of the product, meaning that AI could potentially trigger disciplinary proceedings. It is our understanding that the state will expand this AI across the enterprise, and that before this system expands any further, workers deserve to have guardrails in place so they aren't unfairly penalized when we are monitored electronically beyond the scope of our work. So please support Senate File 4689. We would also respectfully request that you consider reinstating some of the previous language around pre-use notices for these AI tools, workers' access to the data collected by AI, the right to appeal employment decisions reached via an ADS, the prohibition on worker retaliation around ADS use, and the prohibition on allowing employers to solely rely on an ADS to make decisions. Thanks again to the committee for hearing my testimony and to Senator Maye Quade for these bills, and I'm happy to take questions.
Thank you for the testimony. Next up, we have Jake Schwitzer. Welcome, State and Local Gov. Please say your name for the record, and you may begin.
Thank you, Chair Zhang, members of the committee. My name is Jake Schweitzer, and I'm the Executive Director of North Star Policy Action. We're a think tank that promotes data-driven solutions to help working Minnesotans thrive. Earlier this year, we published new research about the impact of artificial intelligence on working Minnesotans. Today, I'm going to summarize just a few key points from that report. First, AI capacity and adoption are accelerating rapidly. Already today, 8 in 10 companies use artificial intelligence. Second, Minnesota's workforce is particularly vulnerable. Our analysis found that 1 in 3 Minnesota workers is in a job with high AI exposure. That is the highest share in the Midwest. But even that number understates the issue. When it comes to AI being used in hiring decisions or workplace surveillance, every worker in Minnesota is at risk. Third, Minnesota has largely stood still while other states have acted. States across the political spectrum, Republican and Democrat, are already putting guardrails in place around AI in the workplace. We are falling behind, and we can't wait any longer. AI capacity is currently doubling roughly every 7 months. That means if we wait until just the next legislative session after this one to take action, these systems will be 4 times more powerful than they are today. In remedying our inaction, Minnesota should focus on what we've referred to as the 3 Ds of AI risk in the workplace: displacement, digital surveillance, and decision-making. On displacement, we are already seeing early signs of job loss, and it's likely to get worse. Workers facing job loss will need time, support, and real pathways to retrain. On digital surveillance, the solution is simple. Employers should not be collecting data that is unrelated to the job. Workers should know that what data is being collected about them, and they should have the ability to access and correct it. No one should be managed by an invisible system they don't understand or even recognize or even realize is operating. And on decision-making in the workplace, there must be transparency around the use of AI. And AI should never be a primary decision maker in important employment outcomes, such as hiring and firing. Lacking this protection, we risk creating a workplace where decisions are made by a black box with no accountability. The bills before you today are a great start, and we urge you to take action to protect working Minnesotans. Thank you.
Thank you for your testimony. Are there any other members of the public that would like to testify on the bill? Seeing none, we will go to member questions or comments onto the bill. Members, Senator Curran.
Thank you, Mr. Chair, and Senator Maye Quade. Appreciate you bringing the bill forward. I know AI is moving fast, but this approach, as described by the testifiers as well, is pretty impactful. The definition of AI and when and where it's not in place, what an employer can and can't do, as it relates to any form of technology. We've had modernization of technology since the beginning of the creation of technology. And I'm worried about the broad definitions, literally touching every scope and aspect of automation of a company, from performance enhancement, quality management. Call monitoring is one of them. We've monitored call monitoring, anybody that's been in a call center from the existence of call centers. And for us to dictate exactly what it should be, what it should look like, and to add the administrative burden and or the understanding who's going to police that and how would AI be identified when it's embedded, whether you know it or not, in every single element of word processing, every software solution that you're using today. There's some element of technical AI into it. And so I fear weaponization again against a one-size-fits-all program that is grossly overreaching into the operational abilities within a company. And now, should an employee be aware? They could be. They should also be aware of many other the terms and conditions of employment when they accept the job. And so I get concerned about some of the testimony as well that said, you know, there's displacement. Displacement's happened naturally or unnaturally, and some within control of a business and some without. And I've heard a little bit of the previous information on the bill is about that it would be an employer's responsibility to then figure out what that retraining capabilities is and bear those costs and impact to changes and dynamics of the workforce and the market and the environment. I find that something we've never done before, and because of a technological change, why would it apply here? And so I have just a whole host of concerns that how we would measure it. I don't think it's ready for prime time, certainly, but this seems to be another one-size-fits-all. And so from a mom and pop shop, they use software which is all embedded in technology, or AI has embedded. And so that's what I'm worried about. And so we have guidelines. So my first question would be, Senator Maye Quade, so we've got guidelines from the Technical Advisory Council, and so minutes get guidelines. Did they help create these guidelines, or were there any recommendations that came out of what they've already got for the utilization of AI, at least in state government and for what we do here?
Senator Maye Quade?
Thank you, Mr. Chair and Senator Cran. Well, I want to reground us in what this bill is actually doing. So all of the definitions that you see here prevent, for example, an automated decision system from being used to keep an employee or to make an employee violate the law, obtain or infer their immigration status, their veteran status, their sexual or health or reproductive history, plan, their emotional or physiological state, sexual or gender orientation, disability, make predictions about their beliefs, their intentions, their personality, their emotional health or state, take adverse action against that worker for exercising their legal rights, or drawing on facial, gait, or emotion recognition technologies. So I hear you that it's a one-size-fits-all. It is meant to be a one-size-fits-all because I'm hoping we can all agree that electronic monitoring tools that are trying to be implanted in an employee's skin, or inferring information about an employee that can't be used to make any decisions because it would be discriminatory, or to surveil an employee in a private area like a locker room or a pumping or nursing area or a religious area, that's what this bill does. It is very narrow to say, it's not that you can't use automated decision systems, although I do have personal feelings about that, and it's not that you can't use electronic monitoring, although I have feelings about that. It's saying that no matter what the tool is, you can't use it for these purposes because, one, it should be illegal, but two, it's harmful both to employees and to a workplace in the state of Minnesota. And Minnesota is behind. And you heard our testifier talk about Minnesota's behind a bunch of states, red, purple, and blue. And so, I did have a more robust bill, one that deals with worker displacement, which is something we absolutely need to deal with because we've never had a technological advancement, certainly in modern history, depending on how you define modern history, that has had a benefit to disrupt so much of the workforce, particularly high earners, and particularly keep out young people from entering the workforce. So in addition to all of the other concerns that I have about AI. So that is what this bill is to get around the worker displacement bill is actually the next one. But this one is to say there is a set of information that employers cannot use AI, whether it's electronic monitoring or decision-making systems, to gather and obtain and then use to make decisions.
Mr. Chair.
Thank you, Senator Coran.
Thank you, Senator Maye Quade. And so with that, you referenced, I guess, deployable wearables, or you said implanted in the skin. So are employers requiring implants today?
Senator Maye Quade.
Thank you, Mr. Chair. Thank you, Senator Cran. Not requiring, but there are employers in the United States of America that have floated having implantable devices in skins. The owner of Twitter is one of them. And there is a Republican bill that deals with this on its own that I'm a co-author on, so it's part of this bill as well.
Thank you.
Senator Coran.
Mr. Chair, Senator Maye Quade, and so I don't know anybody, though that sounds, I've heard about implantables, right? People have done them. I don't know who would do that. I don't know what employee would allow it to be done involuntarily. So I have those concerns as well. But I think this one is a significant overreach and be able to define what AI is in the workforce. And I think there has been equally disruptive technologies in the history of mankind, certainly. Do we all know what it looks like? No, I don't think we do. But I don't think this bill is ready just because of the far-reaching element of every aspect of businesses who are adapting and building more technology every day for workforce improvement to compete in the world economy. So I think it'll set Minnesota behind further behind in businesses who won't even knock on our door, either retain businesses in this state to just retain them more or less and foster them to grow businesses in this state, or even knock on the door to attempt to do new business in this state. So I think it just adds another layer of it. We're not open for business, and weaponizing a regulatory body, which is state governor, our attorney general, and everybody to go after businesses who are just trying to survive in a dynamic economy. So I hope this bill, Mr. Chair, I hope it dies in this committee, and I would encourage we don't support it. Thank you.
Thank you, Senator Coran. Any other member questions or comments? Senator Maye Quade.
Thank you, Mr. Chair. I want to be very clear. Minnesota is not open to businesses that are trying to take adverse actions against workers for exercising their legal rights. Minnesota is not open to businesses that want to use electronic monitoring to force an employee to violate state, federal, or local law, or to prevent them from complying with state, local, or federal law. We are not open to businesses that want to surveil employees while they pump their breast milk, or participate in religious activities, or change in the locker room, or go to the bathroom. Minnesota is not open for that type of business, and we shouldn't be, and this bill would make sure that the way that AI is being deployed, and it is being deployed in our businesses, cannot be used for this incredibly objectionable behavior. And I'm actually very surprised that we're experiencing any pushback saying that Minnesota should allow AI tools to be used to surveil workers in this way. If you had asked me 2 years ago, when we were already in this body, if children would be dying by suicide for talking to AI chatbots, I don't think any one of us, including myself, would have said, yes, of course, that's a thing that's happening. And here we are 2 years later, and that is happening with an alarming regularity. So to say that implantable devices, which is already being floated by tech CEOs around the world, is too far-reaching, I think we might find ourselves back here next session saying, wow, can't believe we didn't do that bill, because here we are 9 months later, and that's happening to workers. So I really hope I can get support to move this bill on, Mr. Chair. I think it's very important, and it does the bare bones, as you heard from our first testifier. There's a lot more that could be done, but this is the starting place of things we should just say aren't allowed in Minnesota.
Thank you, Senator Maye Quade, and you're looking to move this to judiciary, is that correct?
Yes, Mr. Chair.
All right, Senator.
Mr. Chair, has a roll call been requested?
Senator, no, not yet, but.
Request roll call.
Senator Cran requests a roll call. Roll call being requested. Roll call will be given. Senator Maye Quade moves Senate File 4689 as amended to be recommended to pass and referred to judiciary. Staff will take the roll.
Chair Zhang?
Yes.
Vice Chair Gustafson?
Yes.
Vice Chair Maye Quade?
Yes.
Lead Lang?
No.
Senator Barr?
No.
Senator Zwatzinski?
Yeah.
Senator Drazkowski?
No.
Senator Fateh?
Yes.
Senator Hemmingson-Jaeger?
Yes.
Senator Johnson Stewart?
Yes.
Senator Corian?
No.
Senator Matthews?
No.
Mr. Chair, there are 7 ayes and 5 noes.
There being 7 ayes and 5 noes, the motion passes. Senate File 4689, as amended, is referred to judiciary. Next up, we have Senator Marty, Senate File 4511. Senator Marty, welcome to the State and Local Government Committee, and you may begin whenever you're ready.
Thank you, Mr. Chair and members of the committee. Senate File 4511 is a bill that would clarify our law related to gambling, prediction markets, which are something I think a lot of us had never thought of as a gambling tool in the past. We've had a long history of having farmers and others use commodity futures, and that's been regulated by the federal government. It's a legitimate business investment decision-making process. But in recent years, some folks have found that they thought they could use that as a loophole in state gambling laws, and so they're using these prediction markets for people to bet on sports, on political events, on all sorts of other things that are very questionable. And what this bill would do would be to simply say that while we continue to exempt, as our gambling laws currently do, we continue to exempt commodity futures trading stuff if futures contracts relate to any of certain areas which are clearly not investment tools but betting, that in those cases that would be covered by our laws saying you can't do that, should be illegal in Minnesota. With that, I will say that, first of all, a lot of our bills these days have bipartisan authors. This one not only has bipartisan authors, but this one and Senator Rasmusson's next bill, I think coming up, sweepstakes, both have bipartisan authors, but also people who are on both sides of the gambling issue. Sports betting issue, for instance, Senator Klein, a former author of that, is a supporter of this, and I and others are as well. So I think the nature of this is very widespread because Minnesota has done a very good job of trying to regulate gambling opportunities and limits in the state. And prediction markets are coming in here and basically saying, we're legal, you can bet on anything you want, anytime you want. And there are some horrendous examples of how that's happening. And very much one more thing related to it, it causes huge problems with insider trading. If they can bet on, there's already a problem in sports betting where it's easy to throw a game corrupting sports. In politics, decisions related to everything from military things in Israel, they arrested 2 folks who were obviously they were using insider information to bet on certain war strikes and so on. I think this is something we do not want in Minnesota. And so this bill would clarify that our law on bets, that these types of futures contracts would be illegal under our laws, which I think they are, but this is clarification. And with that, Mr. Chair, I have an A6 amendment and would love to have that considered. And I'll either ask the Senate Council to explain the differences to it. Otherwise, I'm happy to. I think it's done as a delete everything because it was restructured in the order of it. But basically, I think the 3 things it did was there was one provision that said if you had a prior violation of this, then you would not be able to get a gambling license for after that. And we didn't need that in here because we already have that in other gambling laws. You disqualified. And the other one is that we added for certain clauses in the bill the types of provisions that would be prohibited, beginning on page 3, line 23 of the A6 amendment, would be that first 2 types are clearly you're creating the prediction market or operating it. The next one, the 3rd category, is people who would be intentionally doing things like providing, administering the odds and that sort of things, that they are working with them. Those, if they're intentionally doing them, they would have the same felony penalty. Then finally, 2 other types that in the previous bill were also covered in the underlying bill were covered, but Senate Council and a number of the attorneys looking at this thought that the way it was structured last time, it would be smarter to take these out of that process and put them under here. They would have been felonies under the last bill, but this simplifies that. And basically, this was the attorney's attempt to clarify the bill and make it better. And Ms. James may have more comments, but with that, I'd ask the committee to consider the A6.
Thank you, Senator Marty. Ms. James?
Mr. Chair and members, I think Senator Marty has explained the changes really well. There's just a lot of work to refine the description of the activities that are a crime.
Thank you, Senator Marty. Any testifiers?
Mr. Chair, we have people here who can answer questions and so on, but we were not asking for witnesses to come. If the committee wants
Thank
to hear
you.
them, there are some who would probably be willing.
Thank you, Senator Marty. Members, any questions or comments to the bill? Senator Barr.
Thank you, Mr. Chair. Senator Marty, I see you've got an effective date on 1st of August this year. If this bill became law, it would probably be a few weeks from now before the governor signs it, realistically sometime in May. Do you think that's enough time for existing companies to actually go through the verification process? Because this would only be, we're talking about international platforms that do this now. Would that be enough time for them to come up with, do you believe it's enough time for them to come up with the verification data to prohibit people in Minnesota from participating in this? And how do you kind of walk me through that, if you would, please?
Okay, several things on this.
Senator
one.
Marty.
Mr. Chair, I apologize. First of all of our standard effective date for new crimes is August 1st. Even if something's really urgent, we want people to have a chance, make sure they understand the law and know the law. In this case, it's a handful of businesses, national, international businesses, who are very aware of what our laws are. Calci, one of them, has described themselves as the first legal national sports betting platform. They know sports betting is not allowed in Minnesota. And so I believe that's enough time for them. And basically, if somebody else who is participating in doing this, they have to knowingly be violating it in order to be subject to the penalty. So, and I believe the director of the Alcohol Gambling Enforcement Division of DPS is here, and they have a process now. They'll usually give a warning letter first, and then they follow up with a cease and desist letter, and that way the person knows and you get time to respond to that. I mean, the goal isn't to prosecute people, the goal is to stop these illegal businesses from operating.
Thank you, Senator Barr.
Thank you, Mr. Chair. Thank you for the explanation, Senator Marty. I'm just kind of curious because we're talking, I don't know if Schwab does this or not, but I know Robinhood, what's that? There's another one that I know that are basically stock market options, things like that. And then they have recently delved into this, and I'm just curious if you think that's enough time for them to actually get it in place. I mean, I know they could probably do it, but you're talking basically two plus months, 2 plus a few weeks, something like that, June, July. I'm just curious if there was, the gambling enforcement, if there's some way. I'm sure it's just something that they have to put on the phone or the mobile app or desktop to say that this is your location, your geo ID on the internet is probably all that is necessary. I'm assuming that's easy, but I just wanted to bring that concern to light. Thank you.
Mr. Chair, Senator Barr, again, the
Senator
geolocation
Martin.
technology is pretty impressive, and these folks use it every day. And most folks in the gambling industry, online gambling stuff, are very aware of it. You can cross the border into Iowa and you can start betting. You cross the border back into Minnesota, you cannot. And so they're very good at that. I believe Mr. Anglin from Alcohol Gambling Enforcement is here if anybody has questions about how it fits together.
Thank you. Senator Drazkowski.
Thank you, Mr. Chair. Thanks, Senator Marty. I'm just looking at the bill. Why do we go from 0 to 100 in the bill with the level of felony in the bill? Couldn't you start with a misdemeanor?
Mr.
Senator
Chair, I believe we were trying to copy the level of penalties for other violations of our gambling laws. This is not you or me betting on something in a system that's not legit. This is for people, businesses that are very profitable making the information by doing this. I think the standard violation, maybe Senate Council can tell what the other violation for unlawful gambling in Minnesota is, but I believe it's the same felony penalties.
Senator Drazkowski.
Thank you, Mr. Chair. Senator Marty, I don't know. So I'm just reading the definitions in the bill. Any event or events happening to a natural person or group of people. And there are parts of the definition that there's a whole bunch of, I'm just reading the bill now, but so if somebody creates a prediction market, so I think about back in the hometown that I grew up in, they used to have a contest, Dunk the Clunk. So they put a car out on a frozen piece of water, and somehow the community wagered on it. And it was kind of a fun activity for them. And I don't know if that applies directly to this bill, but what I'm thinking is there might be events like that or things that people do that we're stifling with this to begin with, but if they end up with a felony or potentially a felony off of something like that or something not intended by the bill because it's new, that's my concern.
Sure. Mr. Chair, Senator Drazkowski, all of our current forms of gambling are clearly exempted here. And type of thing, I mean, raffle types of things are regulated and so on. This does not touch them, does not touch private social bets. You and I, you and a stranger, you and anybody can bet on sports, anything you want. The issue is the platforms who are profiting off of your betting on that. They're the ones who have the penalties. This is not going after somebody who's violated something here, but we clearly exempt the activities that are currently not bets, which include all of those things. They're already defined in 60975 as not bets. And this just adds to, it takes out of one of the exemptions, the commodity futures stuff has always been exempted. We're saying commodity futures are exempted except for these things. So it wouldn't touch any local meat raffle or other types of things, bingo. The things that are legal in Minnesota would remain legal.
Thank you. Thank you, Mr. Thank you, Mr. Chair. Thank you, Senator Marty. So Dunk the Clunk would still be okay. Thank you.
Any other member questions or comments? Senator Maye Quade.
Thank you, Mr. Chair, and thank you, Senator Marty, for bringing the bill and allowing me to be a co-sponsor. You know, I think one thing that we should just make really clear too is that there's just absolutely no regulation on apps like Kalshi. So for example, I have a really good friend who works for an elected official who's planning to announce a run for something else. And I know exactly what day that they're going to announce or that they're planning to announce before most other people know. I can bet on that. The person who runs the campaign can bet on that. The member themselves can bet on that. So this is just rife for corruption, and we've seen that. And so in addition to it trying to be just a too cute by half run around our sports betting laws, it's also just a really, really bad thing for society. And we've seen that play out. And so I'm very, very glad that we'll have a chance to keep this from happening in Minnesota.
Members, any other questions or comments? Final word, Senator Marty.
Did you vote on the A6?
Oh, sorry. The members, Senator Gustafson moves the A6 amendment. All those in favor say aye. Aye. All opposed say no. The amendment is adopted. Now, any other further questions or comments before I hand it off to Senator Marty?
Sure.
Senator Marty.
Madam Chair, Mr. Chair, members of the committee, I very much appreciate the opportunity to present this. I think if you ask people 2 years ago about prediction markets, a year ago, what are you talking about? This year it's gone from down here to here. And I'm afraid, and I think all of the folks who are working in regulation and in Minnesota's lawful gambling businesses and so on, they all recognize this is just totally running under the radar. And a year from now, instead of going up to here, it's going to be through the roof. And I think it's time to regulate it now, and I very much appreciate, not regulate it, to clarify our laws already ban this, actually.
Thank you. And with that, Senator Swedzinski moves Senate File 4511 as amended to be recommended to pass and referred to the Commerce Committee. All those in favor say aye. Aye. All opposed say no. The motion prevails. Senate File 4511, as amended, is referred to Commerce. Thank you, Senator Marty. Next up, Senator Rasmusson. Welcome to the State and Local Government Committee. Senator Rasmusson, whenever you're ready, you may begin.
Thank you, Mr. Chair. Minnesota, like many states, allow sweepstakes as a promotional marketing tool. One example that members of the committee may be familiar with is McDonald's Monopoly game that they run, where when you go through the drive-through and pick up your hamburger, you get a chance to win something. And that is very common. Many states allow this. However, we have seen in recent years, online companies are using Minnesota's sweepstakes laws to offer online gambling. They use what's called a dual currency system, where consumers are able to buy what's called gold coins, be similar to getting the hamburger at McDonald's, but then as a bonus, they get these sweeps coins, which they can use to play gambling games to win a prize. And this effectively allows online gambling in the state of Minnesota. There's consideration. People are putting money in. They're playing a game of chance, a casino-style game, and they have the opportunity to win a prize, oftentimes for money. These games are packaged as slots, blackjack, and other casino-style games, and look and feel like a real online gambling app. Senate File 4474 would clarify and ban these dual currency online sweepstakes games, joining a number of other states who have also updated their sweepstakes laws. I want to be clear that this does not ban social casino games, which people can play for free. And the test is very narrow in this bill. There would have to be consideration, there has to be a casino-style game, and there has to be a prize, which is our traditional test of what gambling is. There's a wide group of people supporting this bill, including those who have been opposed to gambling expansion, such as the Minnesota Family Council, the Minnesota Catholic Conference, and others, in addition to organizations that have current regulated gambling here in the state, whether that's the American Legion, Allied Charities of Minnesota, the Minnesota Indian Gaming Association, or Canterbury Park. And so I'm happy to take any questions that members have, Mr. Chair.
Certainly, looks like there's a couple of testifiers here. Sorry, Mr. Andy Plato. Welcome to the State and Local Gov Committee. Please state your name and you may begin.
Thank you very much, Mr. Chairman, members of the committee. My name is Andy Plato, and I serve as the Executive Director of the Minnesota Indian Gaming Association. On behalf of our 9 tribal nation members, thank you to Senator Rasmusson for his bill to ban sweepstakes casinos. Sweeps casinos are unregulated and illegal gaming platforms that advertise here every day. Internet casinos are illegal under Minnesota law, and these products, which masquerade as free to play, are exactly that. These companies, which operate iCasinos such as Chumba, Stake, and Wow Vegas, offer every casino game imagined and hide behind a deceptive dual currency model designed to skirt existing gaming laws. 25+ states have seen through this deception and responded with bans, restrictions, or have legislation pending. Senate File 4474 follows that lead and rightfully asserts that internet gambling in Minnesota is illegal until the legislature says otherwise. We also thank Senator Rasmusson for narrowly crafting this bill to not interfere with currently legal promotional tools, many of which are used by our members. Any sweepstakes or social game that doesn't use dual currency and casino games should continue to be allowed, and this bill recognizes that. Again, thanks to the bill's author, co-authors, Chair Zhang, and the full committee, Senate File 4474 protects Minnesota consumers and rightfully clarifies these real money casinos are illegal. Thank you.
Thank you. And next up, there's Sarah Erickson with United Strategies. Welcome to the State and Local Government Committee. Please state your name for the record and you may begin.
Chair Zhang, members of the committee, thank you for the opportunity to testify today. My name is Sarah Erickson. I'm here on behalf of ARB Interactive. ARB Interactive is the US-based company behind Modo, the largest US-based social gaming platform, and the owner of Publishers Clearinghouse, a brand with more than 70 years of lawful sweepstakes experience. ARB, along with our competitors, have been operating in Minnesota for well over a decade. Our members share a commitment to ensure that the more than 220,000 Minnesota adults who play these games are protected. We operate under strict internal advertising standards along with robust consumer protections, including 21+ age requirements, identity verifications, geolocation, and responsible social gaming gameplay tools. If this bill passed, it would push our association's longstanding responsible social plus companies out of the state, only to be replaced by illegal operators with exploitive business practices. I want to address some of the statements and misnomers about social plus gaming. There's a lot of confusion about this topic and with respect an incomplete understanding of our industry. Social plus games are regulated. We comply with Minnesota's sweepstakes law and every facet of Minnesota consumer protection law. Additionally, our industry is regulated by at the federal level by the FTC, the FCC, U.S. Postal Service, and DOJ Consumer Protection Division. We do believe that Minnesota sweepstakes laws should be updated for the digital age to provide further guardrails. It was created in the 70s. We want to engage with the state in a regulatory and taxing framework which could generate significant revenue for the state. Social plus games do not compete against casinos and charitable organizations. The way people participate in these games is entirely different than real money gambling. No money or consideration is ever required for a player to enter the sweepstakes. More than half of the participants never spend money to play these games. This bill was introduced late in session, and unfortunately, there's not been enough time for a nuanced discussion to address all these misconceptions. We are asking the committee to give this issue further opportunity for study before enacting a counterproductive ban. We want to work with the members of the committee, tribes, and the public in the coming months to create legislation that would protect Minnesota's consumers, generate substantial tax revenue. We hope to continue this productive conversation, and I'd be happy to stand for any questions.
Thank you for your testimony. And with that, we will go to member questions or comments to the bill. Members, Senator Gustafson.
Sorry. Thank you, Mr. Chair, and thank you, Senator Rasmusson. I like this bill. I did not know that, and because I don't gamble, so is it called Chumba Casino? Is that the one that I think one of your, yep, I'm getting the thumbs up or whatever, yeah.
Senator Gustafson.
Sorry, so I don't know where you all stand on that, but I can't stand the commercials, so that would be my only, my only amendment would maybe be to also ban the commercials for that particular group. But I do think, I just wanted to say that I like your bill, and for a couple of reasons. Is the other day, and I don't think my example is necessarily related to your bill, but I just noticed this in the last couple of years. I'm trying to buy just some like new clothes for work, and I click on this ad, and I get to the ad, and they made me play like 3 casino-like games before I could just buy a pair of pants. And I thought, this is like, all of this stuff is to get you to, I don't know, like stay on their site for a certain amount of time, or like hand over your email, or I'm sure there's a reason why they want you on there, and while they're like continuing to force you to stay on these things. But like, you can't even just buy clothes anymore without it turning into some sort of an online game thing. And so I'm glad that we're like staying ahead of it. I just wanted to say I appreciate it, and maybe you could be open to an amendment that gets rid of the commercials too. Thanks.
Senator, any other questions or comments from other members? Senator Rasmussen, any final words for the committee?
Thank you, Mr. Chair. I appreciate the opportunity to have a hearing on this bill. This is the third committee that this bill's been to, and the only opposition that we've had to this bill are individuals who run online sweepstakes casinos, which would be banned in the bill. And so I just want to make the point that we've talked to organizations like McDonald's, we've talked to the video game industry, we've talked to other people that use promotional sweepstakes, and they do not have a problem with this bill. But those that are offering casino-style games, taking consideration and offering prizes, which is the purpose of this bill. They've been the only group that's expressed concern, so I think this is narrowly tailored and will protect the integrity of Minnesota's prohibition on online gambling.
All right, thank you, Senator Rasmusson. Seeing no further discussion, Senator Gustafson moves Senate File 4474 to be recommended to pass and referred to Finance. All those in favor say aye. Aye. All opposed say no. The motion prevails. Senate File 4474 is recommended to pass and referred to Finance. Thank you, Senator Rasmusson. Next up, Senator Gustafson, if you are ready, and it looks like you have a few testifiers too. Senate File 4745. And it looks, oh, I'll let you get settled in. Senator Gustafson, whenever you're ready.
Thank you, Mr. Chair. Good afternoon, members of the committee. I'm before you today to present SF 4745. It's a bill that brings efficiency, accountability, transparency, and increased integrity to projects funded with state dollars to assure they are spent in accordance with current state law. As you know, it is current Minnesota law that project owners are required to collect and maintain certified payroll reports, or CPR, from all contractors and subcontractors on projects that are funded in whole or in part by the state of Minnesota. A project owner includes all state agencies and local governments or other entities that receive state funding through bonding projects, economic development grants, including the removal of lead service lines in communities throughout the entire state. This proposal will not add or change any reporting requirements for project owners or contractors under current law, or does it make any changes to what information would be available to the public upon request. What it does, it is directs the Commissioner of Administration to establish procedures for contractors to submit those reports electronically through a single centralized reporting tool. Adoption of the CPR portal would relieve state agencies, local governments, and project owners from the burden of collecting and maintaining biweekly certified payroll reporting from contractors through the duration of the project, retaining those records for 3 years following the project and responding to FOIA requests for the reports. The proposal also allows a local government or project owner to opt in for use of the portal for non-state funded projects. For instance, local governments with their own prevailing wage ordinance or labor standards policies, such as the cities of Richfield, Bloomington, Brooklyn Park, Hibbing, and Grand Rapids, can register projects in the portal to realize these efficiencies as well. So we would not be the first state to enact this measure. We would be the fourth, and we benefit from the learnings of Illinois, New Jersey, and most recently New York on how to implement this manner that best suits how we conduct business here in Minnesota, adhering to our statutes and higher standards for direct practices or data practices. So, Mr. Chair and members, I understand there is a good amount of discussion occurring among stakeholders to address concerns about how this would be implemented. While many of those are addressed in the A1 amendment, I expect further improvements to be made as the proposal as it moves forward. Conversations are continuing. So with that, Mr. Chair, I do have the A1 amendment.
All right, Senator Gustafson moves the A1 amendment. All those in favor say aye. Aye. All opposed say no. The A1 amendment is adopted. Senator Gustafson, we'll go through the testifiers then. First up, Bradley Peterson. Welcome to the State and Local Government Committee. Please state your name for the record and you may proceed.
Thank you, Mr. Chair and members. My name is Bradley Peterson with the firm of Flaherty and Hood, here today on behalf of the Coalition of Greater Minnesota Cities. CGMC represents over 100 cities outside of the 7-county metro area, and we are happy to support Senate File 4745. As you know, cities of all sizes across the state engage in all sorts of construction projects that are covered by the state's prevailing wage laws. The range of these projects include water and wastewater treatment plants, public safety buildings, library and other public buildings, and most recently, lead pipe removal and replacement. As such, CGMC supports this bill for a number of reasons. First off, a centralized payroll reporting portal and database would relieve local governments of their current payroll collection obligations, including the ongoing maintenance of those records. Secondly, collecting this information in one centralized place would relieve local governments of having to respond to public information requests on this data. I can't tell you how many times I hear from our city members that responding to public data requests of all sorts is the bane of their existence, taking up a lot of their time. And so even a little relief in this area would go a long way. Finally, as was mentioned, this bill would also allow those local governments that have their own local prevailing wage ordinances or labor standards to opt into the system. There are a number of greater Minnesota cities that do have their own local prevailing wage ordinances, especially in northern Minnesota, that could take advantage of this provision. In conclusion, as an advocate for local governments, I'm often asked, what can the state do to relieve cities from state-imposed mandates and regulations? While the creation of this reporting portal may not be the biggest thing that you could do, it sure does seem like one of the more simpler things that you could do here in the near term. Therefore, we urge favorable action on this bill. Thank you.
Thank you for your testimony on the bill. Next up, we have Joel Hansen.
Thank you, Chairman. Senators, my name is Joel Hansen, Director of Government Relations with Associated Builders and Contractors. We're a construction industry trade group in the state of Minnesota with 365 members that employ over 23,000 men and women in the construction industry. We also agree with the previous testimony that we like the idea of a streamlined prevailing wage portal in which contractors know where to submit their certified payroll forms. Streamlining that process makes it easier for everyone. However, we do have some concerns with the bill regarding protections of employee data and respectfully oppose the bill due to that. So I will direct you to your packets. You have a letter from us that expresses our concerns in great detail, but I will point out lines 1.3 through 1.14 creates a publicly searchable database of employee information. While it's accurate that this information is already available to the public, it's available to the public through data practices requests. As we look at the legislation as is currently written in the DE, it appears as if this would be eliminating or not having that check on it being a public data practices request. We think when it's dealing with employee names, potentially addresses, because I do have a copy I should mention of the certified payroll form in your packets as well, and you can see what information is asked. It's addresses, names, pay information, days of the week that they would be working, hours worked on particular days of the week. It's all information that I think as somebody who's a construction industry worker would want to have protected. I will mention that currently the Department of Labor and Industries has on their registration lookup the ability to look at names, home addresses, home phone numbers of those who are licensed folks in the construction trade, so thinking electricians, et cetera. I can tell you right now, and I encourage you to do this, I looked up, you can find at least one member of the state legislature's home address listed currently publicly. Whereas, you know, if you go to the Senate website, it doesn't even list the hometown of a state senator, whereas this is going to be, because they choose to be in a licensed trade, it lists their home address. So there's some real concerns here that we have regarding the protections of employees' data. I will say we've been working with the proponents of the bill as well as the Department of Labor and Industry on trying to come up with some language that would meet these concerns. But, you know, as of now, I will just say the Minnesota chapter of the National Association of Minority Contractors, Minnesota Minority Goods and Services, Minnesota Chamber the Electrical Association, Minnesota Plumbing, Heating, and Cooling Contractors Association all shares our concerns with the bill as currently written. So again, we respectfully oppose this legislation at this time, but continue to commit to work with the stakeholders. Thank you.
Thank you for that. Next up, Laura Ziegler. Welcome to the State and Local Government Committee. Please state your name for the record and you may begin.
Thank you, Chair Zhang and members of the committee. My name is Laura Ziegler with Associated General Contractors of Minnesota. We represent over 350 general and specialty subcontractors that make up our association. AGC is not opposed to the intent of the bill as amended. However, we are actively working on some key implementation issues that must be addressed for this to function effectively for the construction industry. And I'd like to highlight 4 issues that we want addressed here for you today. First off, we want to avoid duplication. Many contractors already use established payroll systems to meet the current requirements. It's important to us that this does not create a second parallel process that they then have to input, especially if it's any manual data entry. Secondly, we desire interoperability. The system must be able to integrate with existing contractor software. Without that, it does risk increasing the administrative burden rather than the goal of streamlining and improving efficiency. Third, that was just mentioned with respect to data privacy and security. The bill puts detailed payroll information at anyone's fingertips rather than going through a data practices request. We want to ensure that the appropriate safeguards are in place so that sensitive worker information, as mentioned, home address, or the specific job sites are protected and not subject to misuse. And finally, and this is very key, implementation and stakeholder engagement. Our HR professionals and administrators are going to be the ones implementing this and using the system on every state prevailing wage projects. So it is essential that the state works with contractors, software providers, and project owners to design a system that is functional, efficient, and workable for the users that we represent and all contractors across the state. So to reiterate, we want to avoid duplication and ensure interoperability and data security. Our focus is to ensure that the system is implemented in a way that works in real-world construction operations and streamlines the processes already required by law. I want to thank Senator Gustafson for her engagement on this bill, and I'm happy to answer any questions.
All right, thank you. Seeing members, any questions or comments to the bill? Senator Coran.
Thank you, Mr. Chair, and Senator Gustafson. I appreciate you. We talked on the floor a little bit, and so I like the original intent of the consolidation, simplification for the reporting. Any business, any contractors to report in a centralized portal. I appreciate, especially the comments around the true operational efficiencies through the deployment. I know even if we have clear statutory intent, we sometimes don't get it right on the deployment. So we would have to, if there's a way we could make it tighter on what types of interfaces we would allow, we got to make sure that the agencies who deploy and build that meet the contractors where they are, and to be able to streamline it, whether you choose to allow a paper form, right? It may be necessary, but I think some analysis has to be done to what are the most common things to meet them where they are. So it's truly operationally efficient. And even from project setup, that the burden is so multiple, a single business can file all their payroll regardless of the number of projects, right? So it must be able to meet the standards in which they are. So just some operational efficiency. So I think that's extremely important. The other piece, though, is kind of the public data. I think the testifier talked about the pain because of public data requests. And so for me, that's the piece I'm opposed to, is to build the database, great, I'll track all projects from a company name, the project, the total dollars spent for each of those contractors, but I don't think there's any material value to the public information of the employees, of said employees in those companies from a public data perspective. And because it's purely from a regulatory perspective to meet compliance to prevailing wages on these projects. And so with that being said, it's pure regulatory. Dolly or whoever is going to manage that doesn't need, right, they have the employee's name, but there's no purpose for those to be displayed from a public perspective. So with that, and I don't know, we didn't have much time since we got off the floor. I do have 2 amendments, and I'd just like to walk through and or at least understand if you're open to exploring that path. So I'll propose the first amendment, and then we can have a conversation. So, Mr. Chair, I'd like to move the A3 amendment to the amended, or to the A1 amendment of 4745.
Certainly, Senator Coran moves the A3 amendment. Would you like to go over your amendment while it's being passed out? Senator Coran.
Yep, thank you, Mr. Chair. And so what this essentially does is it removes the first part. There's another follow-up amendment. This removes, if you look on line 1.8, it removes everything after the comma, so after performed, all the way through line 12. And so it's about the department maintaining the website and make the searchable contractor project name and all those things available. It removes it. The second amendment would then reinsert it, and that's why it wasn't exactly the way I wanted. And so the intent wasn't super clear, but what it does, it removes that portion, it removes that public disclosure piece, because it currently includes name of employee and all the vital information. So that's the amendment, Mr. Chair, and Senator Gustafson.
All right, thank you, Senator Krantz. Senator Gustafson, or maybe one of your testifiers?
Thank you, Chair Zhang. And yes, I did bring some people who are both been in the negotiations of like further conversations about data privacy. They can also speak to what it looks like, you know, as from the perspective of people who are using this right now. I will say that the current amendment would take information that's already public, then already available, and make it private. So I think that kind of goes beyond the scope of what we're trying to accomplish with this bill. I do appreciate the ideas. I would say no to this amendment, but I've got experts up here who can maybe speak more to why this wouldn't be necessary or needed.
Maybe one of the testifiers?
Madam Chair,
Senator Coran.
Mr. Chair, and Senator Gustafson, yeah, I would, before we move on, yeah, I would love to have the debate because I haven't heard the business case. So why a name would be required to be public for the administration and oversight of prevailing wage, because it's essentially what it is. And so you and I had a conversation that it was, well, it's about public projects and public oversight and transparency. Well, if that was the prevailing criteria for which we used, then we've got thousands of businesses that then have to report for the receipt and for payment of services and the disclosure of all of their employees and information and wages. So that's where I'm at. So I'm looking for the business case of why that information is necessary. And I know it's necessary, but why is it deemed public data today?
Thank you. One of the testifiers?
Thank you, Mr. Chair. I'm going to hand it over. You can introduce yourself, and then he'll be able to probably answer Senator Coran's question a little bit better.
Certainly. Please state your name for the record, and you may provide your testimony.
Thank you, Mr. Chairman and members of the committee. My name is Tim Watkins. I'm Education and Policy Coordinator with the Fair Contracting Foundation. We are a nonprofit labor management committee representing more than 2,100 signatory contractors in the state of Minnesota, as well as 70,000 men and women working in Minnesota's building trades unions. I think there's maybe just a little bit of confusion about what's already required as public data, specifically employee names, rate of pay, labor classification, all of that. Under Minnesota's existing labor standard statute 177.30, that information is already required to be public data. There's a long list of things in that particular line. I don't know them all off the top of my head, but employee names, labor classification, rate of pay, rate of fringe benefits, health insurance, 401ks, that sort of things is already required to be publicly disclosed.
Mr. Chair,
Senator Grant.
just testify, Mr. Watkins, Senator Gus, I thought you had some agency personnel to prove the business case. I know what's currently legal or what's in law. And so, yes, it was, but it wasn't as readily accessible in the touch of a mouse to be able to pull up any and all information and capture all that data if you so choose. And so the business case for, I don't think there's a business case for it, even in the current law, that it wasn't proven to provide value from a regulatory perspective that the public engages or has any means to be able to benefit or understand the regulatory component and how they would help Dolly manage prevailing wage, or any state agencies that they're in compliance with the prevailing wage statutes. So I'm looking for the business case because that's where I want to go. I don't believe that's, now you're modernizing and making it more readily accessible, and the FOIA requests are problematic, but I think just because they've engaged in a bad practice, I want to have the conversation about why do we need it today?
To the testifier.
Thank you, Mr. Chair. One particular piece of information that's useful by being able to see employee names readily available is particularly checking licensing status for like electrical, plumbing, things like that, because as was already mentioned, DLI does have a public database of all of those who are licensed to perform those different sorts of crafts. Being able to see that information on a prevailing wage report allows us to check whether a contractor is properly in compliance with state statute as far as how many licensed workers they have to unlicensed workers, apprentices to journey workers, and things like that. So there is a public value in that.
And you, Mr. Chair, and you forgot non-union members, correct? So,
Mr.
Testifier.
Both union and non-union?
Correct. So, Mr. Chair,
Senator
the testifier, Mr. Watkins, what regulatory body do you represent in state government today?
To testify.
I work for a nonprofit.
Mr. Chair, that's what I'm looking for. So from a regulatory body perspective, that's the government's job to regulate, right? All of the job sites, every statute we have. I understand what you represent, but I'm looking for the government's need for this information to be public. They are they're the regulator. It's their responsibility to make sure people are licensed, and the contractors who hire them, that's their responsibility as well. But to have a public purpose, to provide all the vital information, name, address, all those things, I'm looking for, because it's outside of any licensed contractor. We're talking about government expenditures, and I'm struggling to find the nexus where we have to make that public, because if it's government dollars and you want all that vital information, then we got to do it for all. And I don't see a case for it, and you still haven't made a case for it. And so that's the challenge I have. I like the bill. I like the centralization and the consolidation. But from a regulatory perspective, the public isn't part of that regulatory body. It's their responsibility. And so that's why I'm still struggling with that business case.
Mr. Chair.
Senator Gustafson.
We do have somebody from DLI who is here who might be able to answer the question that Senator Cran is asking. I would also just say, too, that in the spirit of everything that we're trying to work on in accountability and transparency, prevailing wage projects are paid for by taxpayers, and the public has a legitimate interest in knowing whether the contractors for those projects are paying workers what the law requires. So that's the reason behind it. It is being monitored now. It's fragmented. This would keep it more centralized. But to your question, we do have someone from DLI who's prepared to speak.
Senator Crane, would you like the Department of Labor?
Mr. Chair, I would like somebody to be able to declare a material reason on how the Department of Labor industry, whoever's going to manage that, how the public input helps them do their job better.
Certainly.
straightforward
There's a
question.
member.
I don't see anybody
Dolly's-
racing up here.
Please state your name for the record, and you may begin with your testimony.
Thank you, Chair. My name is Josiah Moore. I'm the Legislative Director at Department of Labor and Industry.
My name is Adam Case. I'm the Assistant Director of the Labor Standards Division.
To the question.
Thank you, Chair. As I understand it, the question is, how does having information collected on a certified payroll form be public data help us in our enforcement action, in our enforcement activities for prevailing wage?
Mr. Chair, and testifier, that is correct.
To the testifier.
Thank you. I'm just thinking of Chapter 177.30 that establishes what is collected on that certified payroll reporting form. And that particular statute doesn't speak to whether the data is classified as public or private, but is governed elsewhere. And I would defer to my colleague who works in our Division of Labor Standards and doing the enforcement work as to how that data being classified as public would help enforcement work.
To the other testifier.
Thank you, Mr. Chair and members. I mean, we at the Department of Labor and Industry, do have limited resources and limiting staffing, and we, are not able to, constantly monitor prevailing wage compliance on every project throughout the state. We do receive complaints from, stakeholder groups based on the information that, is already publicly available that they request and receive related to prevailing wage compliance.
Mr. Chair, and thank you. So we're in random enforcement. So your agency is charged with, the priority here is making sure that everybody's employers are in compliance with prevailing wage. You're the regulator. And so now you're going to have, I think, and I'm not talking about should the data be reported. You need everything. That we're not debating. But the public nature of it, besides haphazardly going out there and in a fair and arbitrary manner to apply regulation in a consistent manner across the board. It's your job to do so. You will have all the data. I think a centralized environment now will allow you to do your job better. And I've still not heard a case, except for having a zealot go through data randomly on that thing and make random complaints to you. That doesn't guarantee prevailing wage is done in a unified or uniform, consistent manner, because our job as a regulatory contracts management body to make sure every contractor, every business pays no more, pays no less, has the same regulatory standards applied across the board. You're that body. And I haven't heard a single business case for, because it was public, why it should remain public when we now are going to make it far more accessible to everybody. That's what I'm looking at. So I think in lieu of time, Mr. Chair and Senator Gustafson, nobody's proven the case yet, and I'm struggling why we would move forward. And I don't think my amendment is perfect, but I would look for at least consideration that we move in the case it's at. I don't think I can't support it, but that we look and make sure that if somebody can prove it, Dolly's here. I appreciate you guys being here, but there's no business case to do so. I think we can achieve everything. You'll have better data. We want to make sure it's operationally effective for the businesses and you, so we actually have true compliance and fair regulatory practices across the board. So that's, Mr. Chair, and I'll withdraw my amendment. I want to be able to move forward and have a conversation so we can support this bill.
Thank you. Senator Coran withdraws the amendment, and I appreciate you working with Senator Gustafson. I think Senator Gustafson would be open to it. We are running out of time, and there's another bill that I would like to get to. This bill that will be going to finance, and I hope that members would try to work with Senator Gustafson on this bill. I will be giving you the last word. Senator Gustafson.
Mr. Chair.
Senator Matthews.
Mr. Chair, I'm wondering, with all the
privacy data in this, the Judiciary Committee didn't ask for this bill?
Senator Gustafson, in the pathway for the bill?
Mr. Chair, no, I don't think at the time it was determined that judiciary would need to see this bill.
Senator Matthews.
Mr. Chair, Senator Gustafson, I can't see any universe in where it's appropriate for this to skip the Judiciary Committee, coming from formerly chairing the subset in a previous session of the Civil Law Committee.
Senator Matthews, just in the interest of time, I think I would like to focus on the state gov piece. I understand your concern, but, you know, I don't control what the Judiciary Chair does. But I understand your
The data
concerns.
state gov piece is the gist of what we're talking about here, Mr. Chair.
Yeah, but you're asking if
relevant.
why it should go to judiciary or not. Here, maybe Senate Council can provide some clarification for us.
Madam Chair and members, the bill, as it is, does not change the classification of the data. It's already classified as public data. And the bill does not change that. It does make it more accessible, more easily accessible to the public.
Senator Matthews.
Well, I get that, Mr. Chair. You know, I understand that, but that whole change of making it much more publicly accessible is what we have the data practices and the whole privacy issue for in this committee, in this body as one of our other committees. So I still think that it needs to go there.
Senator Drazkowski.
Thank you, Mr. Chair. Well, I agree. And as I was thinking about this, I think this is what Ms. James said. Even though you've got it electronically now, it still would be open to a FOIA request if Senator Cran's amendment went on. The data would still be accessible to a FOIA request, right? As I understand it.
Mr. Chair and Senator Drazkowski, no, I don't
Senator
believe
Cran.
that I want it classified as not public data from an employee record perspective. From an employee perspective and their particular address and phone number, any of that information, it's irrelevant to the regulatory need for this process.
Mr. Chair,
Senator Drazkowski.
this is the key contentious point of the bill. It would be irresponsible of us not to send it to judiciary. It really would.
Again, I'm not here to debate whether it should go to judiciary or not. We can take a vote on the motion to move it to finance or not. Senator Gustafson, the final word.
Thank you, Mr. Chair. I'm prepared to vote.
What's the motion, Mr. Chair?
Senator Gustafson moves that the bill be sent to finance.
Mr. Chair, I would move to amend her motion to strike finance and insert judiciary.
All right. Senator Drazkowski moves to amend Senator Gustafson's motion to send this to finance, to send it to judiciary instead of finance. All those in favor say aye. Aye. All opposed say no.
No.
No. The motion does not pass. Division, there being division called, roll will be taken. Staff will take the roll on the motion.
Don't you just raise hands?
Sorry, I usually don't do this. All those in favor, please raise your hands. Okay,
Wait, this is division, right?
yeah, okay, so 1, 2. All those opposed, please raise your hands. There are 6 noes and 5 ayes.
There being 6 noes and 5 ayes, the vote does not pass. Senator Gustafson, you're back to your motion. Senator Gustafson moves that Senate File 4745, as amended, is to be recommended to pass and referred to finance.
Roll call, Mr. Chair.
A roll call being requested. Roll call will be given. Staff will take the roll.
Chair Zhang?
Aye.
Vice Chair Gustafson?
Aye.
Vice Chair Maye Quade? Excused. Lead Lang?
No.
Senator Barr? No. Senator Zwatinski?
Yep.
Senator Drazkowski?
No.
Senator Fateh?
Aye.
Senator Hemmingson Yeager,
Aye.
Senator Johnson Stewart,
Aye.
Senator Corian,
No.
Senator Matthews. Mr. Chair, there are 6 ayes and 5 noes.
There being 6 ayes and 5 noes, the motion passes. Senate File 4745, as amended, is referred to Finance. Thank you, Senator Gustafson. And next up, we have Senator Johnson Stewart with your bill, Senate File 2689. And Senator Johnson Stewart, whenever you are ready, you may proceed.
Thank you, Thank you, Mr. Chair. Thank you, members. I will go as fast as I can because I know we have much work to do. Senate File 2689 is the Medical Assistance Protection, or MAP Act. It is bipartisan legislation that will expand the Attorney General's office ability to investigate fraud in Minnesota's medical assistance program, known federally as Medicaid. Before I begin, Mr. Chair, I'd like to move the A4.
Senator Johnson Stewart moves the A4 amendment. All those in favor say aye.
Aye.
All opposed say no. The amendment is adopted. Senator Johnson Stewart.
Thank you, Mr. Chair. The A4 was created in collaboration with the chair of this committee. What the A4 does is addresses the change from the original bill to add, or the change which increases the funding that we're asked for to approximately $1.23 million. And what this does is it allows the Attorney General's office to add 18 new staff members within the Medicaid Fraud Control Unit, which we call MFUCU, to account for an almost tripling of the number of fraud referrals the MFUCU has received. The amendment will allow the MFUCU staff to increase from 32 to 50 people as recommended by the federal government. With those funds, MFUCU could add 11 investigators, 3 attorneys, and 4 support staff to the unit. The reason I'm bringing that before this committee is because that is the section of the bill which is directly related to state and local government. And I have 2 testifiers with me, Mr. Chair.
Thank you to the testifier. Thank you for your patience in joining us today. To the first testifier, please state your name for the record, and you may begin.
Good afternoon. I'm Nick Wonka. I'm the director of the Minnesota's Medicaid Fraud Unit, which has been mentioned is housed in the Attorney General's office. And I'm here today to testify in support of Senate File 2689, otherwise known as the MAP Act, which will help ensure that we in Minnesota continue to be able to investigate and prosecute fraudsters who steal taxpayer dollars that should be dedicated to providing critical health care services to Minnesota's most vulnerable people. Now, I'll start with an overview of who we are and what we do, and I'll keep it brief. Our Medicaid Fraud Unit has existed for over 40 years. We're one of 53 in the country. Every state has one, as do DC, Puerto Rico, and the U.S. Virgin Islands. We investigate and prosecute our own criminal and civil cases. Right now, our budget is for 32 people, all of whom, as I'll cover shortly, spend 100% of their time working in a single area, investigating and prosecuting Medicaid provider fraud and the abuse, neglect, and financial exploitation of vulnerable adults. Now, each Medicaid fraud unit in the country is funded by a federal grant from the Department of Health and Human Services Office of Inspector General. That covers 75% of our funding, but it comes with conditions on what we can and can't do. It requires us to spend 100% of our time on those approved activities, investigating and prosecuting provider fraud and the abuse, neglect, and financial exploitation of vulnerable adults. The provider fraud cases that we do, those cover any type of Medicaid provider. The patient abuse and neglect cases often mean crimes against vulnerable adults or elderly residents in nursing homes, assisted living facilities, and other similar settings. We have original jurisdiction for provider fraud, and we can do that presently under state law. We do not for abuse and neglect cases, but we still do those upon referrals from county attorneys. We also assist federal law enforcement in their investigations. This can include interviews, data analysis, assistance with executing search warrants, and other matters. Our investigators did spend quite a bit of their time last summer and spring on these activities with federal law enforcement. With those federal requirements and funding come certain prohibitions too, however. We're the investigators and prosecutors, but we are not the administrators of the program. For example, federal regulations require us to be entirely separate from the agency that administers the Medicaid program, which here is DHS. So we can prosecute it, but we can't turn off payments on the front end or bar a provider from enrolling, and we cannot do compliance work like that. We also can't investigate or prosecute fraud in obtaining benefits, also known as welfare fraud or fraud in other public programs. Now, as has been mentioned, we have seen our budget is set by the Department of Health and Human Services. It is based on the size of our Medicaid, state Medicaid budget. We're at 32 people. When we went to 32 people, that was in 2019, when our state Medicaid budget was $13 billion. We are now over $20 billion. That is the reason that we are being recommended to expand to 50 people. There are more providers in the program who need investigating and prosecution, and this expansion will allow us to do that. You also heard that our referrals have gone up dramatically. When we went to 32 people, we had 144 unique referrals that came into us. Last federal fiscal year, we had a little over 200 referrals. Already this federal fiscal year, which is a little less than 6 months, we're over 300 referrals. And so this budgetary request is based on the need to address the increased referrals and address the increased size in our state Medicaid budget. And we'd ask that you provide us with these funds. Thank you.
Thank you. And members, this bill, the rest of the bill will be vetted through judiciary, but our portion of it is the appropriations. So we'll go to the Senator Johnson, sir, anything else? Members, questions or comments to the bill? Seeing none, Senator Drazkowski, just in the nick of time. Senator Drazkowski.
What's that, Mr. Chair?
He said just in the nick of
Just
time.
in the nick of
Thank
time.
you. I don't know if I have all my materials here, but how are we supposed to trust this office around fraud? There's no credibility here. We've got an attorney general that met with proven fraudsters multiple times. One was just convicted, one of the people, and they contributed to his campaign. We've got corruption in the attorney general's office, and we are bringing forward a bill to give them more authority and ostensibly more money as well. Yeah, $390,000 in fiscal year 2026, and then another $390,000 in 2027. So give your office more money when the individual heading the office is caught in directly with the fraudsters. The people of Minnesota don't believe you. You don't have credibility in this area. I don't even know why this bill is before us. Mr. Chair, that's all I have. We shouldn't be entertaining this bill today. This Attorney General doesn't have the credibility in the face of the people of Minnesota. He supervised fraud. He was involved in fraud. And the people that have contributed to his campaign and were involved in the fraud have been recently convicted. How do we trust he's going to pursue fraud? Why should we give him any more money? We need to do our fiduciary responsibility and say no to these types of proposals to this particular agency headed by this individual. Thank you, Mr. Chair.
Would the Attorney General's office respond?
Yes.
Senator John,
To the testifier,
my
please
name's-
state your name for the record.
My name's John Keller. I'm the Chief Deputy. And to the questions, I guess, from Senator Drazkowski, the record of the Attorney General, of the Attorney General's office, as it relates to the bill before you, Medicaid fraud, is among the highest regarded in the country. And I think our testifiers already provided that information. As it relates to some of the issues that have that you've referenced, the Attorney General's office published an op-ed that went into great detail. We've recently testified before Congress in great detail about the events. The mischaracterization that you have made has already been rebutted in both or all of those forums, and disagree with the perception that this is not a trustworthy office, and the work of the office itself, especially that before the committee properly in Medicaid fraud with over 300 convictions and $80 million in judgments, speaks for itself. Thank you, Chair Zhang.
Thank you for that. Members, any questions or comments? Senator Drazkowski.
Mr. Chair, Gandhi Yusuf Mohammed contributed to Keith Ellison's campaign on 5/13/2025. That individual was just convicted in the last couple of days of fraud. And as I understand it, he's one of the 5 individuals that met with him and was involved in that meeting. The people don't believe you guys.
I think with that, we'll give you the final word, Senator Johnson Stewart.
Thank you, Mr. Chair. Thank you, members. I look forward to testifying on Monday in judiciary, provided that you pass this bill out of this committee. And I feel very good about being the author of this bill.
Thank you for your work. With seeing no further discussion, Senator, we have to take the vote on the
amendment.
A4 amendment.
Correct.
All those, Senator Johnson Stewart moves the A4 amendment. All those in favor say aye.
Aye.
Aye. All opposed say no. The amendment is adopted. Then Senator Fateh moves Senate File 2689 as amended to be recommended to pass and referred to judiciary.
Is it to rules or to judiciary?
To judiciary.
Okay.
And Senator Drazkowski, did you have a comment? A roll call being requested, a roll call will be given. Staff will take the roll.
Chair Zhang?
Aye.
Vice Chair Gustafson?
Aye.
Vice Chair Maye Quade, excused. Lead Lang? Excused. Senator Barr?
No.
Senator Zwadzinski?
Yep.
Senator Drazkowski?
No.
Senator Fateh?
Yes.
Senator Hemmingson Yeager?
Yes.
Senator Johnson Stewart?
Yes.
Senator Corian? Senator Matthews? Mr. Chair, there are 6 ayes and 3 noes.
There being 6 ayes and 3 noes, the motion passes. The motion prevails. Senate File 2689 as amended is referred to judiciary. Thank you, Senator Johnson Stewart.
It's okay if you have another bill. I do have another one on the file, but there's no urgency.
Yeah, we're probably going to have to push it to Tuesday.
That's okay.
The rest of the agenda, members. And with that, we are adjourned.